May it please the court, my name is Rebecca Harbin, and Matthew Grossman and I represent the appellant in this matter, Anthony Walsh. This matter was originally filed in the Chancery Court for Anderson County, Tennessee, and it concerned competing claims of undue influence between two brothers. However, the scope of this appeal is remarkably limited. Mr. Walsh, my client, Mr. Walsh, takes no issue with the court's finding related to the undue influence exerted by Timothy Walsh over his mother, Joyce Walsh, in the final weeks of her life. I believe that the appellee is going to direct the court's attention to certain circumstances and conduct that occurred in those final weeks and years. However, this appeal is limited to two instruments. A codicil to the will of Joyce Walsh, which was executed in October of 2017, and a quitclaim deed that was executed on January 30th, 2018, more than 4 years before she died. Specifically, Anthony Walsh raises 4 issues on appeal. First, whether the trial court erred in finding a confidential relationship giving rise to the presumption of undue influence with respect to those specific instruments. Second, whether the trial court erred in determining that there were suspicious circumstances surrounding the execution of those instruments. Third, whether the trial court erred in determining that Anthony Walsh had failed to rebut the presumption of undue influence when the trial court completely ignored the testimony of the attorney who prepared those instruments. And finally, whether or not the trial court erred in awarding $49,000 in offsets based on rental income for the real property at issue in the 2018 quitclaim deed. So specifically, first with respect to the trial court's finding that Anthony Walsh exercised undue influence through a confidential relationship with his mother. Our courts require to find a confidential relationship that the dominating party destroyed the free agency of the dominated party. Here, there's simply no evidence that that occurred. Based upon the appellee's own testimony, during the time from 2017 to 2018 that these instruments were executed, Miss Walsh was cleaning her own house, driving herself, doing all of her cooking, keeping meticulous financial records, all things that she was doing for herself. This was not a situation where Anthony Walsh had any destruction of the free agency of Joyce Walsh at this time. The defendant, or the appellee, is going to point to checks that were written years later, to designations on bank accounts, all that occurred years after these instruments were executed. And that's simply not relevant to the issues on appeal. Also, the record is completely devoid of any evidence that Ms. Walsh suffered from any mental or physical deterioration at the time, which is required by the court in the case of, in the Jarnigan case. The court found that there must be some evidence of mental or physical deterioration for the dominating party to have a confidential relationship through dominion and control. And there's just no evidence of that here. Ms. Walsh was in good health at the time these instruments were executed. And so the trial court erred in finding that there was a presumption of undue influence based upon dominion and control through a confidential relationship. With respect to the second issue on appeal, the trial court determined the following suspicious circumstances. The following suspicious circumstances were enough to set aside the 2018 quitclaim deed and the 2017 codicil because the trial court found that these circumstances demonstrated undue influence. First, that Ms. Walsh was approximately 82 years of age, that she had suffered from numerous health issues, including but not limited to mobility issues, severe UTIs, and in 2022, dementia and related issues. That the transactions, account ownership changes, and quitclaim deed were executed without the knowledge of Timothy Walsh, and the unjust nature of the transaction disinheriting Timothy Walsh, and that Miss Walsh had just lost her lifelong spouse, and that she would have been emotionally distraught, and that the transaction between herself and Tony Walsh do not reflect her intentions based upon her 1991 will. First, with respect to her age, the law does not see age alone as a suspicious circumstance. Indeed, there was a case where a 95-year-old woman was found to have validly conveyed property. Actually, it was here. A 95-year-old woman could be of sound mind sufficient to convey property, so that age alone is not something that the court should consider. The other things that the trial court found as suspicious circumstances, that she had suffered from numerous health issues, including mobility issues, severe UTIs, and in 2022 dementia. Again, the trial court's relying on evidence that of her state, her mental and physical state, years after these instruments were executed. And this simply cannot serve as a basis to find a suspicious circumstance in this case.
But it wasn't just the execution of the documents itself, was it? It was what he then subsequently did, given the fact that he had this position as personal representative or whatever he was. He used her money, basically.
Correct, but that was all occurred after. And so there was no undue influence in acquiring this quitclaim deed specifically, because all of those things happened after. And to that point, even if the presumption arose and there were suspicious circumstances, Anthony Walsh rebutted that by the presentation of the testimony of the attorney who prepared those instruments on behalf of Ms. Walsh. The trial court completely ignored all of that testimony, wherein Attorney Knowlton said that he believed that she was of sound mind when he prepared the instruments. When she requested that he did it, he spoke to her privately. And our courts recognize independent advice of counsel as a sufficient evidence to rebut any presumption of undue influence. And that is the case of the Childress case, that where our Supreme Court held that to prove the fairness of the transaction to rebut the presumption of undue influence, the dominant party may show that the weaker party received independent advice before engaging in the transaction that benefited the dominant party. And that's what happened here. And the trial court completely ignored all of the testimony submitted by Attorney Knowlton that Joyce Walsh knew what she was doing. She requested these things to be done on, and that he discussed these things with her privately before she signed them. And then with respect to the last issue, if the court finds that the deed was not the product of undue influence, then any offset for the $49,000 in rental income must be set aside as well, because immediately upon the death of Joyce Walsh, Anthony Walsh would have been the owner of the real property at issue. And so the rent would be, he would not have owed any rent to the estate. And if the court has any questions for me, I can answer them.
I hear none. Thank you. Counsel, you have your time remaining for rebuttal. Counsel, you may be heard.
Thank you, Your Honor. May it please the court, I'm Doug Neckel, Knoxville Bar, represent the appellee Timothy Walsh. I would submit that this case The resolution of this case revolves around one word: credibility. The chancellor specifically found in his final order that the testimony of the appellant, Anthony Walsh, was not credible. There's sufficient, a great deal of evidence to support that finding by the chancellor. The appellant initiated this litigation prior to the death of the mother, and he made a verified complaint filed in the Chancery Court for Anderson County stating that he was an attorney in fact under a power of attorney. That was not true. The chancellor in the order specifically finds that there was a power of attorney that was prepared by the appellant but was never signed. And this was found in the papers in the home office of their mother, Mrs. Walsh. When I took the appellant's discovery deposition, we had that, and I showed it to the appellant. He denied any knowledge of preparing that or having seen that. It was not until he was on the witness stand in front of Chancellor Forrester that he finally admitted, yes, he had prepared that. And it was left in the papers of his mother at her house. What's suspicious, and we'll talk perhaps a little bit, we never did find the quitclaim deed. It was never found in her papers. So the chancellor was disturbed by that testimony and the change of that testimony. In addition, there was some testimony by the appellant that really he didn't have anything to do with this codicil. The 2017 codicil really didn't do anything except it took my client, Timothy Walsh, off as the executor and replaced it with Anthony Walsh. That's the sole, there was no change in the will or it was always, and the evidence is undisputed that Mrs. Walsh wanted her sons to share her assets equally. There's no contrary evidence in the record that shows any other intent. There's some testimony by the appellant that he really had nothing to do with this 2017 codicil, but the truth of the matter is, Mr. Knowlton, who's an honorable attorney, I've known him for 35 years, his firm had done work for the appellant prior to. And then there were some emails showing that he helped facilitate the execution of this 2017 codicil. But what's disturbing, and I think what disturbed the chancellor also, this was all kept secret from my client. At no time was he told that there was a change in the codicil. And then after this codicil was done, the appellant undertook certain actions to the detriment of my client and to the detriment of the estate. He took over the bank assets, got his name of Mrs. Walsh's bank accounts, became not only a co-signer but a co-owner and a beneficiary. He did the same thing with the Voya retirement plan, where he changed the beneficiary to become the sole beneficiary. He did all these steps that we've set out in the brief after this codicil, thinking that he had some authority on that. All in secret. As a result, and this was mentioned in the last argument, but this specific finding by the chancellor that his testimony is not credible when it comes to the quitclaim deed in this codicil, he has a strong burden to overcome and to rebut that. It has to be clear and convincing. In this case, there was no evidence that they put on showing that the chancellor was in error. I think Chancellor Forrester, he has a very detailed final order that the court's seen. He's listed out in the paragraphs the specific findings, the suspicious circumstances. As the case law says, there's no set number that we have to show or that the court has to find. Each case is fact-specific, as this one is. But he found that, here's Mrs. Walsh in 2017 loses her husband of 60-plus years. Her husband had always done the finances. She had not been involved in financial affairs at all. Following that, his death, she went to Mr. Knowlton to determine whether or not there needed to be an estate set up for the husband. There was, it was found not to be necessary. Then at some point, evidently, she undertook some steps to keep her assets out of probate also. And she relied upon the appellant, Anthony Walsh, to help her with the affairs. Now, they're saying there's not a confidential relationship, but during the trial, I asked, and it was elicited at several points, well, what role did the appellant have in regards to handling his mother's affair? And he called himself 7 things. He said, I was acting as co-operator, a facilitator, an executor, a co-signer, a joint tenant, co-owner, and attorney in fact. These are all things that he self-described was his role in regards to his handling the financial affairs of his mother. It was clear from that and from the surrounding circumstances that he was a dominant party in this relationship, and that by virtue of this codicil and by virtue of Mrs. Walsh allowing him access to these accounts, that he had unrestrained access to these accounts, which he took advantage of by making himself the sole beneficiary, by writing checks to himself for his own personal expenses, all unknown to my client. And in some respects, the appellant admitted that Mrs. Walsh did not know of some of these transactions, and some of these transactions had been done without her permission. So the chancellor was correct in finding that the appellant was a dominant personality, that he had the ability to influence and exercise dominion and control over her, and did so. And you know, at that point, when there's a presumption of undue influence, when there's a confidential relationship that arises, as we know, and if it's followed by a transaction, as they were in this case, where the dominant party receives a benefit without consideration, then that's voidable. And in this case, the quitclaim deed on the house and the rent and the other assets should be returned to the estate. We told Chancellor Forrester on day one that my client, when he was appointed power of attorney upon legal advice, he went in and changed all the asset ownerships back to himself to protect those assets. We have every dime of those assets that belong to his mother ready to go back into the estate. None has been dissipated. We told the Chancellor, that's why we're not appealing the findings, because there's nothing to appeal. We're ready to put that money back in. However, the appellant, there was a $214,000 Charles Schwab account that belonged to his mother that's already been spent and dissipated by him for his own living expenses.
Is all of that part of the record?
It is. It is. And in the findings by Chancellor Forrester. The suspicious circumstances, advanced age 82. Of course, as we're progressing through our 70s, maybe that's not as advanced as it once was, but she did have medical problems. Back in 2000, she developed heart problems. She'd been diagnosed with myocardiopathy, and had been under treatment for years with a heart doctor. And then I think in 2012 or somewhere, several years before this codicil and all that, she had a very terrible fall, suffered permanent back injuries, suffering constant pain, mobility problems. And they're saying, well, she was still in her right mind, but that's not the test. The test is, was she being dominated? And the appellant at trial, and realizing Ms. Harbin was not trial counsel, But at trial, he brings in this chart, I think it's part of the record, showing all the visits that he had made to his mother's house and how she relied upon him to cut the yard or clean the fish pond or even fix her TV remote. She evidently had problems with that. So she became increasingly reliant upon him to do those things. My client is legally blind. He's somewhat limited in that. However, the appellant was very, I guess, proud to show all the times that he had been over there. What the chancellor disturbed was the day that this quitclaim deed was executed. She had a calendar. Mrs. Walsh had a calendar. She was very careful of doing it. She put down 10 o'clock appointment with Mr. Knowlton. The appellant was there 2 times that day, and yet he denies saying he knew nothing about the quitclaim deed. And that just didn't fit in with the other evidence of the missing quitclaim deed, his constant presence in the residence, and the chancellor considered all that and made a finding. It should be respected. Concerning Mr. Knowlton, again, great lawyer, he was very candid, and he didn't do anything I haven't done. I get calls all the time. Well, I need a quitclaim deed. Okay, well, send me the name of who you want to quitclaim it to. Come in, sit down with them, make sure nobody's pressuring them. You know who the president is and what the day of the week is. Here it is. There was no comprehensive legal advice asked for by Mrs. Walsh, nor is there anything in the record to show that any comprehensive legal advice was given by Mr. Knowlton. He says, I don't know anything about the family. I just did what Mrs. Walsh told me to do. That doesn't meet the criteria of the Richmond versus Christian case, which says it has to be comprehensive, and the evidence is totally devoid of that. He did basically what Mrs. Walsh told him to do. She was not advised of the consequences. And one other thing that at trial, I moved to amend my pleadings to allege that there's no proof of gift. And there wasn't any, and there still isn't. At no time is there any proof that Mrs. Walsh had the necessary donative intent to make a gift of this house. You say, well, she did the deed, she recorded it. That's not donative intent. In fact, the whole record shows that she wanted to treat her sons equally. And that's what Chancellor Forrest has done in this case. And that's what this court should affirm. Thank you.
Thank you, Counsel. Counsel, you have time for rebuttal.
Thank you, Your Honor. Mr. Nichols said that this case revolves around credibility. Importantly, the testimony concerning Mrs. Walsh's physical and mental health in 2017 and 2018 all came from Timothy Walsh. It did not come from my client, so there was no credibility determination as to that testimony. Ms. Walsh was competent at that time. Next, there's no credibility determination as to Attorney Knowlton's testimony. And Mr. Knowlton testified as follows as it relates to the quitclaim deed and codicil. I got a call, according to the notes in the file that was sent to me, I got a call from Mrs. Walsh saying that she wanted to convey her interest, I don't know if she said quitclaim deed or what, to Tony, and what did she need to do? And I told her that what she needed to do was to bring the document back to me, the deed that she was talking about, and we would have to prepare a quitclaim deed, and she would have to be there to confirm that that is what she wanted to do and execute it. Mr. Knowlton also testified, when questioned, and to your recollection, or from a review of your file, did Tony have anything to do with procuring this quitclaim deed? Answer, nothing that I know of or can recall. The Chancellor's ultimate finding was completely silent as to whether or not Mr. Knowlton's testimony was sufficient to rebut this presumption of undue influence that he found based upon a confidential relationship between Joyce Walsh and Anthony Walsh. Moreover, opposing counsel points to the actions that Anthony Walsh took with respect to the bank accounts that occurred after this codicil was executed. But the codicil itself did not give him the right to do that. The codicil would only come into effect after Joyce Walsh had died. This was not the instrument that gave him the right to make any designations on a bank account or write checks. The two things are completely separate. And so we contend that the record does not reflect the complete destruction of the free agency of Miss Walsh, sufficient to find a confidential relationship between Anthony Walsh and Joyce Walsh in 2017 and 2018. The suspicious circumstances simply are not reflected by the record because, first of all, there was no diminished capacity of Miss Walsh. There was no secrecy around the quitclaim deed because it was recorded in the registrar's office. There was no significant stress on her because Attorney Knowlton testified that he believed that that was what she wanted to do when she contacted him to convey this property to her son. He did not find that she was under any duress or that Tony had anything to do with this quitclaim deed, and the Chancellor simply ignored that testimony in ruling on these issues. And if the court has anything else, I can answer.
No, hear none. Thank you, counsel. The court thanks counsel and parties for being here today, your briefs, oral arguments. That will conclude the hearing, and you are free to go. Mr. Clerk, if you would please adjourn court until the next setting.